Hello, everybody, and good afternoon. My name is John P.L.L.C. I'm a guardianship and probate litigator with P.L.L.C. Hauser in downtown West Palm Beach, Florida. Our firm limits its practice to disputes, guardianships, appeals, and trials, including for such probate topics as trusts, estates, and inheritances. I'm going to be speaking to you for the next hour on guardianship litigation, a guide for Florida probate lawyers. We'll be talking about recurring problems, pitfalls, best practices, things that you can do in your practice that hopefully will assist you, whether you're preparing wills and trusts, preparing estate plans, you're an elder law attorney, you're a typical probate or estate planning attorney, you're preparing documents for clients who may be in their golden years, as well as for guardian attorneys or guardianship attorneys. Those people have a major practice in guardianship court, which is our probate courts here in Florida, and you're handling guardianship matters every day. So we're going to be talking about those issues for the next 50 minutes, not 50 hours. And at the end of the course, you'll get a course number so that you can get credit from the Florida Bar. The Florida Bar has approved this as a continuing legal education course. And so you'll be able to get credit for the time that you're spending over the next hour or so. Before we get into the discussion topics, let me invite you to check out our website, phflorida.com or pinkowskilawfirm.com. There is a section on videos where you can attend or download or link to free continuing legal education credit if you're a Florida lawyer. There's a number of CLEs that my firm offers for free. There's ethics credit there. It's about 4.5 hours of ethics credit for free. And there's also a number of probate topics that you'll find of interest if you're a probate lawyer. Our approach with these CLEs is really to help our colleagues who are probate lawyers, estate lawyers, elder law lawyers, guardianship lawyers, trust lawyers with their practice. And so I hope that the perspective is helpful. I hope that the tips and the pointers are insightful and they help you with your practice. So let's look at our discussion topics for the next hour. We're going to talk very generally about what a guardianship is. We're going to talk a little bit about a private versus a public guardianship, including an appeal by my law partner, Robert Hauser. We're going to talk about who is safekeeping the original documents of a client. For example, a healthcare surrogate document, a power of attorney, or even one's revocable trust. And that's important from an evidentiary and a procedural standpoint that, quite frankly, many guardian or probate lawyers often overlook or don't even attend to. We'll talk about avoiding what I call guardianship by committee, why multiple persons serving as a guardian or in any fiduciary role for that matter can be more problematic than realized. We're going to talk about the legal tension that we see out there in the guardianship world. And when I talk about legal tension, I'm talking about two separate sets of facts. One is adult children from a prior relationship and the ward's present spouse. And the second one is the role of the court, right? The role of the probate court in protecting and looking out for a ward, an alleged incapacitated person, versus taking his or her rights away. I want to talk about a very specific fact pattern where a second or third marriage actually works and how the incapacity of his or her spouse can cause a lot of heartache and legal fees. I'd like to next talk about what is the effect of a guardianship proceeding when you already have an existing estate plan. We'll discuss who your trustee is of your revocable trust and why. We'll spend some time talking about examining committee reports, and whether you need to supplement those reports with your own expert medical evidence or a medical expert. I want to talk about some procedural and evidentiary issues, hearsay objections and guardianship trials. We'll look at the Fernandez case, which should not come as a shock to you, but is nonetheless very helpful. We'll look at the broad issue of standing in guardianship proceedings, and we'll mention one case that I think everybody knows, and then we'll discuss another case that some, quite frankly, might find a little interesting. And then we'll talk very briefly about objecting to inventories, acts, and failures. So one of our questions might be, why are we here today? Why are we listening to John P.L.L.C, a probate litigation attorney in Florida, talk about guardianship matters? Why is this probate litigator addressing these issues? And the short answer is there's about 56 trillion reasons why we're here today, right? The Boston College Center of Wealth and Philanthropy reports that $56 trillion are being passed right now from our older generations, like the World War II generation, to subsequent generations. It's the largest wealth shift in humankind. It seems that everybody's litigating over it. I mean, guardianship litigation has exploded, and everyone's lawyering up. Right? If you asked me 15 years ago if I was going to handle guardianship matters, my answer was no. And now it seems guardianship litigation is a part of our practice where we're in court every week for, and helping people with the changing landscape of Florida guardianships is something that we're doing almost every day. And it's a very, very important part of our practice now. So we're going to talk about what a guardianship is. And, I enjoy writing, and I'm working on a guardianship guide or a guardianship book for the layperson. And I expect to finish it in 2017 and have it published either this year or in 2018. And if you'd like a copy, feel free to email Amanda@phflorida.com, or you can call Amanda at 561-514-0900, extension 101. Until then, until my guardianship guide comes out, I do have 2 books that are available for you for free if you'd like. P.L.L.C's Trustee's Guide, everything you need to know about serving as trustee of a family trust, and beneficiary rights. A lot of discussion of beneficiary rights is included in that book. And I have a probate litigation guide where I talk about some of the common estate planning mistakes that we see out there every day in our practice. So what is a guardianship? Why are we here? What is this legal concept? Well, a guardianship is typically a legal proceeding, right? That means something's been filed in a court. And in Florida, we go to our circuit courts, right? Guardianships are not handled at the county level, the county court level. We're in the circuit court, where a guardian is or may be appointed to exercise the legal rights of an incapacitated person. So there's a couple of important points there in that wonderfully simplistic definition from the Florida Bar. One is generally you only need a guardianship if someone is determined to be incapacitated, unless it's a voluntary guardianship, and that requires a finding of fact, right? Very, very important. And then you have somebody, a guardian, exercising legal rights for that person. So the significance of a guardianship proceeding is a court of law is taking away or diminishing someone's rights. And that is serious, serious stuff, right? I mean, our human rights, our civil liberties, those are things as Americans we take very, very seriously. And so before a judge is going to do that, there's not only due process, right, an opportunity to be heard and notice of that, but it's something courts are reluctant to do unless there's a clear reason to do that, such as we've got to protect this incapacitated person. And for our discussion today, for our CLE today on Florida guardianship, we're talking about adults. We're not talking about minors, although we need to be cautious because guardianships are often needed for minors. But we're going to be talking about incapacitated adults today, right? And it seems everybody has a story or understands or knows some type of guardianship where there's a caregiver involved, and sometimes caregivers become beneficiaries of wills and trusts, and many times people view that as unseemly. So in guardianships, people often need help with personal decisions, right? Very, very personal decisions. Now, the picture on the screen in front of you is of Sumner Redstone. Mr. Redstone was the chairman and CEO of Viacom, and he was the subject of some very highly focused litigation within the last year, where he was accused of changing his estate plan, including those he was placing in charge of his fiduciary appointments, his fiduciary roles. And there was a disagreement between, evidently, Mr. Redstone, his daughter, his adult daughter, and one of Mr. Redstone's prior girlfriends, who evidently had been named in prior documents. And so this girlfriend raised some issues about Mr. Redstone's capacity, and his capacity was called into question. So very high profile, a lot of light on the issue of guardianship and whether somebody has the capacity to change their estate plan and, in essence, remove somebody from a fiduciary role. Here in Florida, those of us who have a litigation practice involving probate, estates, and guardianships handle those issues every single day, right? And we have guardianship trials, and we have evidentiary hearings every single day in our circuit courts and in the probate division. Now, in addition to personal issues, right, when we talk about guardianships, we can talk about a guardian of the person and a guardian of the property. And one of the hot topics in Florida guardianship is divorce, right? Can you get divorced if there's a guardianship proceeding filed, or can that marriage be annulled? And if you ask 10 different probate lawyers or guardianship lawyers, you're going to get 10 different answers. And if you ask 10 probate litigation lawyers or people who handle guardianship trials, you'll probably get 20 different answers. But take a look at 744.3215 4C as in cat. 744, as you know, is our guardianship code, the Florida Guardianship Code. It lists all our guardianship laws. But 744.3215 4C addresses an issue of divorce, or at least starts to address an issue of divorce when the guardianship petition has been filed, right? And increasingly, that's common, right? Getting called in to assist a family with a alleged incapacitated person who may or may not need assistance, may or may not have an estate plan, and has a spouse. And the spouse doesn't get along with the alleged incapacitated person's adult children. And there's tension there. A recurring theme we're seeing all the time in Florida guardianship courts. Or adult children being in charge of their adult father, who is the ward now, and the parent, the ward, mom or dad, gets a boyfriend or girlfriend that the adult children don't like or the guardian doesn't like. Another tension we see increasingly every day. You can also have a guardianship over the property, right? We know if you're incapacitated, you can't exercise personal rights. You don't have the ability to do that. Well, you also shouldn't be managing your money, right? So you have to ask yourself, who's going to pay this person's bills? Who's going to pay their federal income taxes? How about their real estate taxes, credit card bills, P.L.L.C bill? Who's going to pay for their medications and the service providers, particularly if there's a care professional, right? Like an at-home assistant or assistant nurse, companion. How do we get awards bills paid, right? And when we're talking about property management, money management, whether a person has a trustee already or a money manager, or whether there's going to be a guardian of the property, control becomes a very important issue, right? And so many times we fight out in probate court the vying for control of mom or dad's purse, right? The children want to control it and be guardian of the property versus the latest spouse. Or maybe if there's no spouse, one child versus another child wants to control mom or dad's property. And within this mix of legal tension and property control, you have to ask yourself, if mom or dad is incapacitated and they've remarried, they have a spouse, how do you get money to that how do you get money to that spouse if the alleged incapacitated person has all the money, right? If the ward has all the money and you're going to get a guardian of the property, how is that guardian of the property going to interact with the spouse? Because in Florida, spouses have an obligation of support to their spouses, even including when there's a prenup, right? Because prenups cannot waive support obligations during a marriage. They can predetermine property rights upon death and divorce, but public policy dictates that you cannot make anyone agree that you don't have to support them if you marry them during the marriage. So my law partner, Rob Hauser, who is board certified by the Florida Bar in Appeals and Appellate Law, successfully argued a guardianship appeal in 2015. The case was Legal Aid Society of Palm Beach County versus the guardianship of Jennifer Jaffe, Jaffe. And, we'll be speaking throughout today's course on private guardianships. But there are also public guardianships. And this case from November 4th, 2015, 4th District 15-357, you can actually get a free copy of this opinion by going to the 4th District Court of Appeals website, hitting opinions, and then searching for it by date, November 4th, 2015. This opinion does discuss Florida's public guardianship law and public guardians and public guardianships in Florida. Now, we know that a person may need a guardian if they suffer from Alzheimer's or dementia, but that's not the only reason to have a guardianship, right? Dementia and Alzheimer's are diagnosed by doctors whose symptoms include memory loss, but there may be other reasons beyond dementia and Alzheimer's why someone needs a guardianship. And so when we're talking about guardianship, we are talking about human rights, right? We're talking about personal liberties. On the screen now in front of you is the Legal Aid Society guardianship appeal that my law partner, Robert Hauser, successfully handled. And there's a picture of Rob. In our old office at 120 South Olive Avenue, downtown West Palm Beach, we are now located at 415 South Olive. We occupy the entire building, which is just blocks from not only the federal courthouse and the main courthouse, but the new 4th District Court of Appeal, which is being constructed as we speak. So when we're talking about a guardianship and we're discussing what rights somebody has and what rights may or may not be taken away, take a look at 744-33215, right? 33215. Take a look at that for a moment, because that area that statute, excuse me, lists what rights may be removed from a person. So if you look at 744.3215 of the Florida statutes, or the Florida Guardianship Code, or the Probate Code, you'll see it discuss all about what rights a person who is determined to be incapacitated may have removed. And so a probate court judge is going to balance the protection of the ward, the testimony or reports of the examining committee, those who have interviewed the alleged incapacitated person, and then determine what rights should be taken away. I mean, can this person vote, marry, determine where they're going to live? Can they travel? Can they have a driver's license? Can they seek or retain employment? And if you want to read a little bit more about the powers and duties of a guardian, you can look at 744.361. Very, very important, right? Because many times family members in these contested guardianships don't like the fact that a guardian was appointed. And so they may call you and say, I don't like what the guardian is doing. And then you have a conversation about, well, what is the guardian supposed to do? What are their powers? What are their duties? What are they doing? What are they not doing? And usually it comes up that they want the guardian removed. That is a full-blown trial that can be very costly. It's very fact-intensive. And what you have to do is you have to counsel these prospective clients that, look, you know, just because the judge disagreed with you and appointed somebody that you didn't like to be the guardian, doesn't mean you get another bite at the apple. If you think that the ruling was erroneous and there was, you know, there was not competent substantial evidence to support the judge's findings, you need to appeal that. You need to appeal the order or the judgment appointing the guardian. What you can't do is, in knee-jerk fashion, file a petition to remove the guardian just because you don't like the person that the court selected as the guardian. So be mindful of a removal action against the guardian. You need very, very specific facts to do that. That was our first broad discussion about what a guardianship is. That was our #1 topic on discussion topics. Let's now pick up the pace a little and move through the rest of the discussion topics. And let's start with #2. Where are the original documents? And this issue really has to do with issues of evidence and authenticity. Why do I say that? I can't tell you how many times we ask prospective clients who call up our law firm about a will contest or a guardianship proceeding or a matter involving a power of attorney or a revocable trust, who has the original documents, right? And particularly in a guardianship proceeding, we're going to be talking about avoiding a guardianship or a lesser restrictive alternative, and we're going to be talking about, I have an existing estate plan, I don't need a guardianship. Who has the original documents? I need those at trial, right? Unless everyone's going to stipulate that these documents are valid copies and that they exist and blah, blah, blah. I've got to get the original documents to introduce them at trial, right? Or I need to somehow demonstrate why I don't have the original documents. And I can tell you that one of the common issues that we see time after time is prospective clients call up and say, well, I know there's a power of attorney, or I know there's a will, or there's a trust document, and they're just wrong. And they're wrong because it may or may not have been amended, and it's sometimes wrong because no one's got those documents, right? And if you can't produce an original document, that's an entirely different evidentiary and procedural matter for your guardianship trial, right? That throws everything into a different chapter, right? Depending on whether you're objecting to those documents or you want those documents upheld and enforced. So where are the original documents? One of the first questions that people should be asking prospective guardianship clients, and we're talking about the documents which appoint a pre-need guardian, documents which evidence a person's intent of who they want to serve as their guardian if they become incapacitated, healthcare surrogate documents, advanced healthcare directives, powers of attorney, revocable trusts, etc., etc. Avoiding guardianship by committee. I think this gets thrown into the pitfall or best practice area of this CLE. And we're talking about naming a guardian, choosing or selecting who's going to be your guardian if you need one. And I see it time after time that you folks, right, probate, estate lawyers, estate planning attorneys in Florida who prepared documents for a client, you struggle with clients' personal feelings. You say, who do you want to be the guardian? And the client says, well, I have 3 children. And if I only name one, the other 2 are going to be upset and they're going to be hurt and they're going to be insulted. So let's name all 3. And so you end up having a guardianship by committee. And, my observation is, I don't know that makes sense, right? How are you folks going to govern? Are you going to have monthly calls? Who's going to sign checks? All 3, just 2, just 1? You can work by majority vote, but you have to take a vote. And, from a drafting standpoint, right? From a drafting standpoint, you've got to make this clear. I mean, I can't tell you how many times I've seen drafting gaps in documents which we've been asked to review. One common example that we see repeatedly is I name as my guardian Amanda and or John and or Alex. And I don't know what that means. Are you naming all 3 of us simultaneously, right? Consecutively, like all together, we're all going to serve, we're going to have this committee? Or is it successively? All right, I name Amanda, but if she can't serve, then I name John. And if John's not around, I name Alex. So when drafting these appointment documents or these guardianship documents for clients, if you have an elder law practice or an estate planning practice, one way that you can make it abundantly clear is to absolutely spell it out. And if your client wants a guardianship by committee, say, I name the following 3 persons as co-guardians, Amanda, John, and Alex, and they shall serve by majority rule. And if one of them ceases to be a guardian or is unable to serve, then the remaining 2 shall serve. And if the other one can't, we'll have the remaining person be the sole guardian. Or if you're looking for successive guardians, you're just naming alternatives. I name Amanda as my sole guardian. If Amanda is unable or willing to serve, then I name John as my sole guardian. If John is unable or willing to serve, then I name Alex as my sole guardian. A little more care with drafting will help all of us avoid hiring a trial lawyer to go to court and have a judge interpret a document which adult children or others can fight over, right? Let's move on to legal tension in the guardianship world. When I'm talking about legal tension, I'm talking about a couple of sets of facts. One is, and chuck this into the perspective category. Judges are bending over backwards, doing a really good job trying to protect the alleged incapacitated person, right, the ward. Right? We know in Florida guardianship law that someone who is accused or alleged to be incapacitated is often referred to as the AIP, the alleged incapacitated person. And if they are adjudicated incapacitated, they become a ward of the guardianship proceeding. And so judges really do a good job. They really bend over backwards to try to look out for and protect this ward. And at the same time, they struggle, right? There's this tension because they want to protect the person. If they're incapacitated, that means they have to remove rights, right? And so, whenever we remove rights from somebody, I mean, that's serious stuff, right? The second tension that we see repeatedly is the legal tension between adult children from a first or prior marriage of the ward with the latest spouse, right? How many times does that happen where the spouse is living with the ward, taking him or her to the pharmacy, the doctors, all the doctor's visits, waking them up, putting them to bed, helping them with the meals, helping them with the caregivers. Oftentimes that spouse knows the most about when the ward's supposed to take his or her meds. And then you have the adult kids who don't live in the state of Florida, who live somewhere else, don't like the adult spouse, don't like the second and third spouse. Views the second or third spouse as someone who's just going to take all the money that would otherwise be quote unquote family money, which would be the adult kids' inheritance. Right? A fact pattern, a legal tension that we see repeatedly played out in trials throughout Florida in the probate division. So that's a great segue into our fifth topic, which is the case of the loving third spouse getting shortchanged, right? So consider the third spouse who's married to the ward. There's a prenup, and the prenup says, if we divorce, you get X, I get Y, or if I die, you get X, I get Y. But recognize in Florida, our Supreme Court has said that, look, spouses cannot waive support obligations for a spouse during the marriage, right? If you try to get your spouse to waive your right of support to him or her, that's invalid. You have to support your spouse during the marriage. And so when you have these guardianships with a ward who is advanced in years, with a second or third spouse and adult children who may not get along with that second or third spouse, the issue of the prospect of divorce always comes up. Whether you can file for divorce or not, and whether it's appropriate or not. But what happens when the second or third spouse's marriage to the ward actually works, right? That second or third spouse can actually get shortchanged. And the reason for that is many times that second or third marriage involves a prenup, right? You have a prenup that limits property, inheritances, or distribution upon death or divorce. And if somebody has a prenup, in most cases, they also have a revocable trust. And revocable trusts typically say things like, my trustee can distribute money to or for my benefit during my lifetime, and when I die, it goes here or it goes there. You used to see language in trusts that talked about distributing assets for me and my spouse during my lifetime, and you just don't see that as much anymore. And so when we have somebody who is advanced in years, who is now the subject of a guardianship, who has a loving third spouse or second spouse, and the marriage works, right? It's a loving marriage, but the kids have hired a law firm, the adult children from a prior relationship or a prior marriage of the ward have hired a law firm because they don't like the spouse, or they're very concerned about how much money is being spent or used and who's going to control that money. Huge legal tension we see time and time again here in Florida in the guardianship context. And so you've got to ask yourself, you know, is that spouse getting shortchanged because in many cases the ward has named his or her adult children as his or her successor trustee. And what does that mean? It means that the spouse who loves the ward, who's washing or bathing or working with his or her caregivers, taking him or her to doctor's appointments and pharmacies and reviewing scripts and records and getting information to the doctors that need to be conveyed. Many times that spouse has to go hat in hand to the adult children from the prior relationship who are now trustee. Legal tension. What if I've got a plan in place? What if I already have an estate plan, right? You go to a good probate attorney in West Palm Beach, Florida, or you have your top-notch estate planning lawyer in Boca Raton, and you say, whoa, wait a minute. Why are you talking guardianship with me? Why are you talking elder law? I've got this top-notch estate plan in place. I've got everything taken care of, don't I? Well, maybe or maybe not, right? And we can talk about the way guardianships are supposed to work, and sometimes how they do work. And we'll discuss this whole issue of a lesser restrictive alternative, and we'll talk a little bit about alternatives to guardianships and verified statements, which is really a hot topic in Florida guardianship law. So the way guardianships are supposed to work, if you have an estate plan, is somebody files a petition and says, I think John is incapacitated. Judge, you should take away his rights and appoint a guardian after you declare him to be incapacitated. And someone comes forward. It might be the ward's lawyer. It might be the ward's family members. It might be the ward's successor trustee of his or her irrevocable trust or living trust. It might be his or her power of attorney, right? The attorney in fact, and says, hold on, judge, we don't need a guardianship. The ward has already made his or her decisions regarding who he or she wants to be in charge of her or him and their property if they become incapacitated. They have an estate plan, and everything's taken care of. In fact, you don't even need a guardianship, right? Now, you can take a look at 744.331, right? It's kind of been described as the legal roadmap for about everything you need to know about filing a petition, right? But take a look at 744.3316B, right? A requirement for our judges in Florida in a guardianship proceeding is that they must, right? That's obligatory. They must consider whether there's an alternative to the guardianship process. But the analysis doesn't begin there. The alternative, when a probate court considers whether there's an alternative to a guardianship, the analysis must continue. It really matters, you know, what's being considered is whether the alternative to the guardianship will sufficiently address the problems of the incapacitated person. You might have an alternative to a guardianship, but for whatever reason, it's not going to sufficiently address the problems of the ward. And in that case, you're going to have a guardianship. But generally speaking, in Florida, if you have an estate plan in place, a typical estate plan, will, living trust, named a trustee or a successor trustee, and a power of attorney and some healthcare documents, you have a plan in place to make personal decisions for you, or you've appointed those who can make personal decisions for you, and you've appointed someone to safeguard, protect your money, you don't need a guardianship. Do you have a power of attorney? We've got a brand new, I shouldn't say brand new, it's a few years old now, Chapter 709, all about powers of attorney. You should know, however, that upon the filing of a guardianship petition, the power of attorney is suspended. Read 744.3203. This often causes a lot of frustration for those attorneys in fact, right? If you're the attorney in fact, if you're the power of attorney of a Florida POA, and you try to move money or pay bills after a guardianship petition has been filed, your power is suspended. And you have to recognize that. How do you unsuspend it? You get an order from the guardianship judge. Healthcare documents, you can have advanced directives for healthcare under Guardianship Code 744.3115. If somebody has predetermined who's going to make their healthcare decisions for them. And then read 744.462, the determination regarding alternatives to guardianship, right? That kind of sets forth a review of the ward's estate plan. And this is all going to be done in a probate court. So now towards that end, here's a hot topic in Florida guardianship law. If there's a power of attorney or an existing estate plan, people opposed to that can file what's called a verified statement. And if you file a certain type of verified statement saying that you believe that those documents are invalid, right, then a court has to consider that verified statement. And some guardianship litigation law firms would tell you that the way Chapter 744 is drafted, that it requires a court to unfairly or unduly consider that verified statement. What you need to do is read the Searle v. Bent case. Read the Searle v. Bent case because it addresses head-on a case involving a verified statement. Read 744.331. Read 744.462, right? And it deals with a verified statement and how a court considers or doesn't consider a verified statement that calls into question the validity of one's ward's estate plan or power of attorney or revocable trust. And if somebody has a revocable trust, one of the questions that always comes up is the trustee before the court or not before the court? Can a judge in a guardianship proceeding order the trustee to do things or not do things? And it all comes down to procedural and constitutional law. Does that judge, that probate court, have jurisdiction over the trustee of the ward's revocable trust, right? And has that trustee been properly served? Was there service of process so that trustee is properly before the court? For that issue, you can read the Beekhouse case, Bekhus v. Morris, 89 Southern 3rd, 1114. It's a 2012 case from Florida's 4th District Court of Appeal, 89 Southern 3rd, 1114. The 4th District Court of Appeal in this guardianship appeal discusses a probate court having jurisdiction over a trust or a trustee. And it discusses two important cases on this jurisdictional issue. The Chafin v. Overstreet case, 982 Southern 2nd 11. That's a 5th District Court of Appeal case from 2008. And the Manufacturers National Bank of Detroit versus Moons case, 659 Southern 2nd 474. That's a 1995 4th District Court of Appeal case. Very important issues on the procedural front, because at some point in time, if there is an existing estate plan, you're going to want to do something. The parties, the court, are going to want to do something with the ward's trustee and trust assets, even if it's just pay his or her bills. And if you want a judge to order that trustee to do something, you have to have jurisdiction over that trustee, right? And so that trustee may or may not need to hire a guardianship litigation law firm, or it may choose to just observe the proceedings and not participate. You can also read the Graham case, 970 Southern 2nd, 438. It's a Florida 4th District Court of Appeal case from 2008 involving a healthcare surrogate. Okay, let's move on to our 7th topic. We're around the bend. We're heading home. We're almost done. Who's your trustee? One of the issues that you need to consider is who is that trustee of the ward's revocable trust. We discussed a lot at length a few moments ago about getting that trustee in front of the probate court if it's appropriate, and whether the probate court has jurisdiction over that trustee. Understand that you cannot contest the validity of a will in Florida until the death of the decedent. Understand that under the Florida Trust Code, you're not entitled to an accounting or any rights under that trust as a remainder beneficiary until that trust becomes irrevocable. Many times in a guardianship proceeding, interested persons are asking the court to make a declaration that awards a estate plan, a recent will, a recent trust, or a trust amendment, or a restatement of a trust in Florida is invalid. And so you have a collision of these legal maxims and these rules. Most trusts, by their terms, permit, most revocable trusts, by their terms, permit one person and only one person to amend or revoke that trust, and that is the grantor, the creator. And if the grantor or the creator loses capacity and is adjudicated incapacitated by a judge, that trust is now irrevocable. Keep that in mind from a procedural and evidentiary standpoint if you're litigating trusts in the management or administration of a trust in a guardianship proceeding. Examining committee reports. A couple of pointers, practice tips, and other matters regarding that. First of all, examining committee reports are hearsay. They're being offered for the truth of the matter asserted. You just can't walk up to the judge and give them to him and ask the judge to consider them even though he or she will read them. You actually have to move them into evidence, and a foundation is required to introduce them into evidence. You actually need to call a witness, demonstrate that they have personal knowledge of these statements. You typically call the individual examining committee members to testify about their interview with the ward and the committee report that they presented, and you move it into evidence. The other way to do it is by stipulation of the parties, that they all can come into evidence without an objection of hearsay or authenticity. But understand a couple of things. One, if the examining committee reports were done not in the recent past, the court may ask you to get more recent examining committee reports, right? That's very commonplace in contested guardianships. You start off, petition is filed, right? Everything starts moving. An attorney is appointed for the benefit of the ward. An examining committee is appointed. Examining committee members begin to interview the ward. Examining committee reports are filed, and the parties litigate and keep going. And one of the current concerns that the probate courts have is, do I need to get an updated committee report, right? Because there are provisions in the code to ask a court to restore your rights, and people can get better, right? So judges want current medical reports and examining committee reports. That's one point. We talked about the admissibility of the reports, whether by stipulation or by calling witnesses, because they are hearsay. the third point to remember about that is, do you need to bring in your own independent medical expert to testify or to conduct an examination of the ward beyond the examining committee members? Hearsay objections and guardianship trials. All right, as we are at or approaching the hour, let me try to motor through these topics by saying that, you know, I mentioned earlier that you just can't hand a guardianship committee report to the judge. You actually have to move it into evidence. It needs to be accepted into evidence. And the objections need to be overruled. You need to lay a foundation. Guardianship matters are trials. The rules of evidence apply. Chapter 90 applies. You need to raise objections. Read the Fernandez case, 36 Southern 3rd 175. That's out of Miami. It's a 2010 Florida 3rd District Court of Appeal case. And it says just that, right? It says exactly that. That courts should not be prohibiting people from calling witnesses. Courts should not be prohibiting you from introducing evidence, right? That should not happen. So we talked about the Graham case a little bit earlier. The Graham case is a 2008 case, 970 Southern 2nd 438, Graham versus Florida Department of Children and Families. And that talks about a healthcare surrogate and Florida Guardianship Code 744.3316B. And it talks about the burden and procedural and evidentiary niceties regarding a healthcare surrogate, right? If you come forward with a healthcare surrogate that's valid, it's an original document, you've got ink on those signatures, right? There's a presumption as to its correctness, right? There's a rebuttable presumption of clear, you know, that it's correct and valid, right? That's clear and convincing evidence of the ward or the principal's designation of the surrogate. What do you want to do if you think that's invalid? You got to overcome that rebuttable presumption of clear and convincing evidence. You need to demonstrate through evidence that that healthcare surrogate is invalid. Hire your lawyers, get your law firm, get your documents, conduct discovery, interview witnesses, make your opening statement at your trial and call your first witness. Standing, finally. Somebody from the street just can't come in and participate in a guardianship proceeding. Understand the basics, consistently the basics. Is the person that you are litigating with even permitted to participate in this proceeding? Does he or she have legal standing? And while it's true that the 2006 Florida Supreme Court case, Florida, of Hayes v. Guardianship of Thompson describes or discusses legal standing as rather broadly, there are more recent cases that limit one's ability to participate. In fact, we're seeing cases being handed down that kind of surprise some of us. You know, 5 or 10 years ago, if you asked any elder law lawyer in Florida or a guardianship litigation lawyer, they would tell you that children absolutely have standing in a parent's guardianship proceeding. But courts seem to be looking at, notwithstanding Hayes, they seem to be looking at the issue of standing with greater scrutiny now, right? So, you know, does a son have the ability to participate in the father's guardianship proceeding? Is the son an interested person for a guardianship proceeding? Read the Bivens case, 147 Southern 3rd 549, Florida's 4th District Court of Appeal, Bivens v. Rogers. Also read the Zellman case, 2015, 175 Southern 3rd 871. Those are 3 cases that you need if you're discussing standing in a guardianship matter. You need to understand how those cases interact with each other. Objecting to inventories, acts, and failures. Make sure you do it. Sometimes your time frame is as short as 30 days. Remember, not doing something implies consent. So you need to do more than argue at a guardianship hearing. You often have to file documents that will get you there. In conclusion, let me invite you to attend future CLEs if you're a Florida probate lawyer for free, offered by P.L.C. by checking with our website from time to time. There's also a number of CLEs online that you can attend and watch for free. And you'll get the CLE reference number at the end of each seminar, at the end of each CLE, and it'll also tell you how many credit hours you get for ethics or general or elder law or wills, trusts, and estates if you need certification credits. My name is John P.L.C. We don't prepare estate plans. We don't write wills and trusts. We litigate. We handle disputes, trials, and appeals involving wills, trusts, estates, guardianships, and inheritances. We'd be pleased to work with you or your clients and return them to you when the matter is over. If you have any questions, we'd be happy to run a conflict check and offer a free consultation with you or your clients. Just email amanda@phflorida.com so we can conduct a conflict check. Thank you for attending this CLE for Florida probate lawyers on guardianship litigation, a guide for Florida probate lawyers. My name is John P.L.C., and this concludes our CLE.